So good morning, everyone, and welcome to our summer HR Law webinar. As you know, I'm Joanna Chatterton. I head up the Employment and Immigration team here at Fox Williams. I'm joined by three of my colleagues this morning. Our professional support lawyer, Kerry Kirby, is going to look at the developing trends in relation to diversity and inclusion and the key D&I steps that you might want to consider within your organisations. I'd also like to introduce you to our new associate, Katrina Hennessy. She's going to discuss hybrid working. That seems to have been the #1 on the hot topic list for some time now, but that's really because some of the trickier issues are now starting to become clearer. Katrina is going to provide some guidance on how to manage these. My fellow partner and head of our immigration team, Sasha Schoenfeld, will also provide an update on immigration developments, focusing on what sponsor licence holders need to look out for this year. I'm also joined, as usual on this webinar, by Jess Bennett, who's done a fabulous job in organising this and many seminars that we've done. This is her last webinar with Fox Williams, so I wanted to just say a big thank you to Jess for all her input and help over the time that she's been here. Now, we're going to be recording the session, so it will be available after this morning on our website, or we can circulate it to you so you can pass it on to colleagues and watch it at your leisure. We, as usual, will take questions at the end. Please add them to the Q&A function at the bottom of your screen. And then just finally, before we start, it would be great to hear from you if you would be interested in joining us in person for the next HR Law seminar, which is planned for mid-November. We're currently considering whether to offer this as a hybrid event, because we know that everybody enjoys meeting each other face to face. So if you are interested in attending in person, it would be great if you could just drop a note, maybe into the webinar Q&A or to any one of us or your usual contact at Fox Williams, and say whether you're interested in attending in person, and then we can make a decision as to whether to run it in that way. So Jess, if you could flip across the slides for me, thank you, and to the next one. So before we really get started, I should mention that, I suppose, the elephant in the room, the lack of employment bill in last month's Queen's speech, despite repeated government promises since 2019. So our legislative developments are a little thin on the ground, and the changes we were expecting, which are highlighted on the slide, have been shelved for the time being. There are still a couple of changes on the cards, so if you could have the next slide, please, Jess. In response to the public outrage at the P&O ferries redundancies and the way in which they were conducted, we're now expecting a new statutory code of practice on fire and rehire practices. The government has confirmed it's going to be published for consultation this summer, and it's going to apply when an employer wants to push through changes to terms and conditions by dismissing those who protest and offering to re-engage them on their existing job, but with the new contract terms. We understand that employment tribunals will have the ability to increase compensation awards in unfair dismissal claims by up to 25% for a failure to comply with the code, much like the current ACAS code on disciplinary and grievances. The last three new parliamentary bills on the slide are not directly relevant to employment law at first glance, but they are likely to have some knock-on impact from employers, and we'll keep you updated as they make their way through Parliament. Do look out for our updates on HR Law, and if you don't get these emails, or you'd like colleagues to get them, then please do drop us a line and let us know the email address we should send it to, and we can pop them onto the mailing list. It's all free of charge. So I'm now going to hand over to Kerry to talk about current diversity and inclusion trends. Thank you.
Good morning, everyone. I'm Kerry, the PSL in the employment team, and I'm going to chat to you today about diversity and inclusion. So, as we know, diversity and inclusion is pretty high on the corporate agenda now for many businesses, and employers are much more aware of the benefits of having a diverse workforce, better morale, higher retention rates, and a broad range of employee experience and skill sets. And employees also now expect D&I issues to be taken seriously and to see tangible progress from their employers. So I thought I'd start this morning by just looking at some of the different ways that we are seeing employers approach D&I before I think about the potential risks and offer my suggestions on proactive steps that you might want to look at taking. So one of the things that employers can do is to set up a D&I committee, and we're seeing an increasing number of medium to large employers going down that path. The committee will normally play an advisory role, so guiding senior management teams on different potential initiatives. And to get the most out of any committee, it's normally made up of quite a broad cross-section of the workforce, so that discussions will be meaningful and will also involve a wide range of views. Establishing D&I initiatives and setting different aspirational targets for improving diversity is also another common approach. And the aim might simply be to increase awareness in the first instance, so publicising support for things like Pride Month, which we're in just now. We've got an external speaker coming to Fox Williams later this week to talk about his experiences. Or it might be more specific to the organisation or the sector, for example, aiming to increase the number of women who take up careers in an industry which is historically male-dominated, such as construction. Setting targets can be quite a useful marker in the sand, but the problem is they don't really get you very far unless you've also got someone who's responsible for pushing the business to actually achieve them. So some businesses will look at having a workplace equality champion who will monitor equality issues, oversee training, and act as just generally an internal role model for D&I progress. And in any event, it is generally a good idea to have someone at a senior level who will be involved and will have sufficient authority to actually instigate change and potentially also be held accountable for any progress. Diversity in senior leadership appointments is also often under the spotlight and in the press, and there's quite prescriptive targets when it comes to the larger companies that might be listed, for example, but even smaller businesses can self-check in that sense by ensuring that your recruitment and promotion policies are up to scratch and are genuinely accessible and inclusive to all. Mentoring is another effective way of encouraging equality of opportunity, and typically what you get is more senior employees supporting and advising their junior colleagues to help with career progress and development. But it could also be aimed at particular underrepresented groups, and it could also be external. So you might say focus on university students who might have shown a particular interest in taking a job in the sector. And just finally on this slide, I just want to mention another way to encourage diversity is to look at the support you offer to older employees who might be keen to remain in their roles and to retire later for a variety of reasons. So things here like a menopause policy, developing a supportive culture around occasional sickness absence, and also perhaps an employee wellbeing programme. These are all things that might actually help with progress in that regard. And that leads me to look on to the impact of the pandemic. So if I could have the next slide, please. So Kat's going to highlight shortly, sorry Jess, if you could just go back one, thank you. Kat's going to highlight shortly that many employers are now obviously working under a new norm of hybrid working. And that ability to work from home on a long-term basis may well be a real potential benefit to those who've previously struggled to take on an office-based role. And that could be because of accessibility issues or difficulties doing long commutes or working a longer day. And I'm thinking here of carers, of parents of young children, of disabled employees, for example. And working from home certainly gives them a wider range of opportunities. And for employers, it opens up a much broader talent pool to select from. And in terms of just thinking about the knock-on impact on employment law, we do think that there will be some potential changes. And this kind of tweak in working patterns probably means that when it comes to things like looking at reasonable adjustments under your obligation pursuant to Section 20 of the Equality Act when it comes to disabled employees, it's probably something you need to think more creatively about. So it's likely to be harder now to argue that you can't adjust a job at all so that it can be performed from home and still has to be done 100% in the office. And maybe you do have some roles where that will be true and you'll be able to justify that. But if you've already had some level of home working and hybrid is now your new norm across the business and there's no noticeable detriment to the business, then employees may well query why such a reasonable adjustment couldn't be made. I've put a few examples of the usual reasonable adjustments on the slide, but the main takeaway here is really that employees are likely to have higher expectations of what their employer can accommodate post-pandemic. So really it's best to just keep an open mind and consider things that might not previously have been possible or on the table. And that's going to stand you in the best stead in terms of making sure you comply with your Equality Act obligations, but also generally it's going to encourage a more diverse workforce. Next slide, please, Jess. So no talk on D&I is going to be complete really without a look at the potential discrimination risks that could crop up. So you're no doubt familiar with the 9 protected characteristics in the Equality Act, and those include sex, race, age, etc. And I should just clarify that, we lawyers tend to default to the legislation, but when I'm talking about the concept of diversity, it's obviously much wider than just the protected characteristics in the Act. It could include social, demographic, cultural background, and cognitive strengths, just a much wider range of points. But when you're looking at potential legal liability, the 9 characteristics are specifically protected from direct discrimination, indirect discrimination, victimization, and harassment under the Act. So that means that any steps you do take to increase your support for protected groups need to be thought through quite carefully so that you're reducing any risk of potential employment claims. So as a general concept, it's unlawful to positively discriminate. And that means, again, as a general concept, that you can't treat someone with a particular protected characteristic more favourably than someone without. And when I say that, we need to sort of really put disabled employees and sort of pregnant women and new mothers to one side while we're talking about this. Because what I'm getting at is that you shouldn't have a blanket policy that say only recruit women or only recruit those from certain ethnic minority backgrounds or employees over 55, for example. And even if all of that is done with a view to encouraging the overall diversity of the workforce. I'm sure you know this already, but I just want to flag the difference between positive discrimination and positive action. That is a concept under Section 158 of the Equality Act. And it works a little bit like a slightly more general reasonable adjustments mechanism. So it allows employers in certain cases to take proportionate steps to lessen any disadvantage that groups who share a protected characteristic might suffer from, or to increase their participation in certain types of roles if it's clear that they're underrepresented. The difficulty is it's quite limited in practice. So the typical examples we tend to come across are targeted job adverts or running specific targeted open days for certain groups, with a view to encouraging more applicants from that protected group, or offering mentoring schemes. So the issue is it doesn't really take you all that far. There is also another section, 159 in the Equality Act, which provides for positive action in recruitment. And you may have come across this. It's the so-called tiebreaker scenario, which applies where you've got 2 candidates of equal merit, so who are as qualified as each other, but you choose to take account of an underrepresented protected characteristic. For example, you might choose to recruit the woman over the man. And this really tends to be relied on quite rarely in practice, probably for obvious reasons, because the conditions under the Equality Act that you have to satisfy are quite stringent, and it is relatively high risk in terms of the potential for claims. So what I would say is that there's no doubt that trying to encourage diversity can be a sort of tricky area. And we've seen recently that there has been a bit more appetite from some white male claimants to run discrimination claims, particularly if the perception is that their employers have overreached in their diversity and inclusion efforts. So even if you're trying to do the right thing and you're trying to fix an inherent imbalance in the workforce, you do need to tread quite carefully. And I think taking advice at the relevant time is a good idea. And what you could find, for example, is that the potential discrimination claim pops up from a surprising section of the workforce. So reverse ageism is one to look out for. And we wrote about this a few weeks ago in HRLaw, because if you increase the number of older employees in the workplace, there is potential there for tension with their younger colleagues, because obviously there are competing interests. You've got one group who might want to stay on for longer, whereas the others possibly looking for promotion opportunities and career progression. And it can sometimes feed top-down prejudice against younger employees. So everyone's aware of that sort of much publicised negative perception of millennials and Generation Z, the idea that they're less inclined to work as hard as their predecessors. And that sort of unconscious bias can feed through. And because of that, we do think there is potential for more age discrimination claims to pop up in the tribunal over the coming years. Next slide, please, Jess. So that's the potential risk, but I want to think practically about what you can do to put your best foot forward on D&I issues. I think first off, you need to assess where you're at the moment. So doing a D&I audit is a really good way to highlight any challenges so that you can consider how best to address these. And the starting point might be to make sure that your D&I initiatives are embedded into your wider business strategy. Preferably start from the top. So if you've got senior management engagement, your employees are much more likely to respond positively if they think that diversity truly matters and they can see that tangible action is being taken. You could look at implementing a committee if you don't already have one in place. And I think just generally it's worth checking your existing remuneration process. You want to make sure that it's gender neutral, there's no obvious gender pay gap, because clearly that could fly in the face of any other positive steps that you take towards improving diversity. And also it could cause you problems from an equal pay perspective. Do also think about your current equality and anti-harassment policies. Are they still up to date, and do they support what you're trying to achieve? As we know from practice, not everyone's going to read a policy from cover to cover, so that means training really is the best way to get the message across. Preferably start from the induction process for new joiners, and then try and keep the training going regularly across the whole business. We have had a question about D&I in the context of internal investigations, and what I would say is that you should look at all your policies and practices holistically. When it comes to the tricky issues with investigations, I think that warrants a session almost in its own right. So we will probably write about that in a future HRLaw edition. So do look out for that. Final couple of points here. Creating a speak up culture is really important. So employees do need to feel confident that they can come forward about any inappropriate behaviour. They need to know that their complaint is going to be taken seriously and that there's not going to be any retaliation that they need to worry about. And because I think diversity is something of a moving feast, it's a good idea to try and work out the best way to measure it within your organisation. Things like equality monitoring, carrying out anonymous staff surveys, these are all helpful options that you could consider. Next slide, please, Jess. So just finally thinking about what lies ahead for diversity and inclusion, the FCA recently introduced new reporting requirements for listed companies, and those apply now to financial years that started or will start on or after the 1st of April. And listed companies now need to include a statement in their annual financial report that sets out whether or not they've met board diversity targets, and that's on a comply or explain basis. And just briefly, the targets are that 40% of the board should be women, and a woman should hold at least one senior board position, as well as one member of the board being from a minority ethnic background. And we're also waiting on more detailed proposals about how the FCA intends to drive diversity and inclusion generally in the financial sector, and we're expecting those later this year, so we'll obviously update you when we receive them. As Joe said, there's no employment bill on the cards at the moment, but we could still see a new proactive duty on employers to prevent sexual harassment, and also the reintroduction of the duty to prevent third-party harassment. I think it's a good idea to keep these in mind so that they don't come as a surprise, even if the timescale for their introduction has been delayed somewhat. And finally, I just wanted to touch on pay gap reporting. We obviously already have a regime for gender pay gap reporting for employers with 250 or more employees. But back in March, the government confirmed that it isn't going to introduce compulsory ethnicity pay gap reporting. Instead, the regime is going to be voluntary, and there will be some government guidance published over the summer to support employers if you do choose to voluntarily report. And when it comes to disability reporting, mandatory pay gap reporting on that ground also isn't on the cards. There is a consultation on disability workforce reporting, and we're waiting for the response from that, which I've been told is not imminent. However, one of the proposals on the table is to report on the proportion of employees who identify as disabled in the workforce, rather than to report on any disability pay gap. So that's me now. So I hope you found that useful run through of the key issues. I'm going to hand over to Kat, and she is going to explain why hybrid working is still a hot topic.
Thank you, Kerry. Good morning, everybody. So hybrid working, it remains a hot topic this year, primarily because many employees are still getting to grips with the long-term implications for their business. What we are seeing from publicised surveys from the Office of National Statistics, among others, is that hybrid working is a growing trend that is here certainly to stay. That's definitely the case for office-based roles like professional services and the finance industry, where sometime in the week working from home is now fairly commonplace and relatively uncontroversial. The majority of our clients are taking that approach in some shape or form. But what's right for one employer in a particular sector won't necessarily work elsewhere. Hybrid working patterns tend to increase the higher up the income bracket you go. And there's definitely no one-size-fits-all approach, particularly when it comes to maximising the potential business benefits, such as a happier workforce, sustained productivity, future resilience, and potential cost reductions if you need less office space. To some extent, new working practices are a process of trial and error. We've always recommended that clients retain the flexibility to adapt hybrid working practices in light of changing business requirements, as well as to address any tricky issues that might emerge. One trend we have noticed is a growing tension between employer and employee expectations. In some cases, employers will want to see the majority of their workforce in the office at least 3 days or more per week, whereas the optimum for employees tends to be no more than 2 days, mainly because employees have adapted their lifestyles around working from home. And in some cases, they are reluctant to reintroduce the cost and time loss associated with regular commuting. Achieving the right balance does pose a problem for employers, particularly when they're competing for staff in a tight labour market. The ability to work on a hybrid basis is now a big part of an attractive employment package. That also means employers have to consider whether to introduce different pay rates according to employees' working location. You've probably seen in the news about the law firm Stevenson Harwood. They're an example of this, of where an employer took a creative approach. They've offered staff the option of a 20% pay cut to work from home permanently with the odd visit to the office. That doesn't come without its problems, but presumably they spotted some employee appetite for that option and they decided to respond in that manner. If you are thinking about following suit, we'd definitely recommend taking advice on the potential legal risks first, particularly in relation to the impact on employees with protected characteristics under the Equality Act. Today, I'm going to focus on two particular tricky issues in connection with hybrid working, one being the managing the risk of employee burnout, and the second being protecting confidential business information in a remote working environment. Before I dive into those two points and topics, I just thought it'd be worth talking about the interesting results we've received in our recent HRLaw survey. You may well have filled it in, and if you have, thank you. It's been a really useful way to analyse the collective mindset in relation to hybrid working. We'll also be publishing the results in a future edition of HRLaw, so keep an eye out for that, and that will come with some top tips for managing different work patterns. So here we are, thanks Jess for changing the slide, that's perfect. The survey results. The results themselves have shown that 45% of those who responded to the survey expect employees to be in the office 3 days or more each week. Some comments on the responses included that there can be disparity between roles, with a trend towards junior employees showing a keenness to attend the office. Almost a split on whether or not there was a consultation on working pattern preferences before implementation of the hybrid working policy. Most seem to have consulted, but 45% of those who responded to the survey did not consult first. In addition, the majority responded that there have been no complaints or grievances related to hybrid or remote working practices. That being said, almost 50% confirmed there have been mismatched expectations between employers and employees. So it looks like there could be something going on or sort of due to sort of brew in the background there maybe. There was a split in respect of employees relocating further away from the office, but interestingly, 14% responded to say they actually didn't know if people have moved away or not, which I think is interesting. Can you go to the next slide, please, Jess, for some more survey results? Perfect, thank you. There was an overwhelming response to whether or not employees are permitted to work abroad. And actually, we've had a question about this as well. Everyone who responded to the survey said they don't permit employees to work abroad. So it seems that the trend is, the answer is they're not permitted to work abroad. But there are some exceptions to this, where employers will agree to working from abroad for a short period of time or on an ad hoc basis. And that's normally often subject to prior approval. For all sorts of reasons. There's quite a few complications with working abroad, including the tax implications, work permits, excuse me, carrying out risk assessments, ensuring confidentiality, etc. That in itself could be a whole topic that we could discuss and talk about, so look out for that in the future as well. The majority of respondents to the survey, they reported an increase in staff morale and wellbeing since working from home. There was also a small percentage of those who responded saying there had been cost savings associated with working from home, which I think that we were maybe expecting a higher percentage than that. And it seems that the morale and the well-being is the sort of driving force. So I'm going to move on to talk about employee overwork. Could I have the next slide, please, Jess? Thank you. One of the key potential health and safety issues for employers to monitor is the danger of employee burnout, and that's associated with working from home on a regular basis. Some employees will encounter difficulty enforcing boundaries between their work and home life. Add in feelings of isolation and the lack of colleague support that working in office can provide, and the situation can very quickly escalate into stress and anxiety. In some cases, employers have become used to 24/7 availability and the idea that they can ask employees to hop online at the dining room table no matter what time of night it is. Contrast that with working in the office, where there's a physical separation when an employee walks out the door and a subconscious acknowledgement that the working day has come to an end. We are hearing common stories of employers and employees reporting burnout, stress and exhaustion following the last few years, particularly post-pandemic. This can easily have a knock-on effect for the business, with increased staff turnover and the loss of talent, a negative impact on reputation in the market, and future problems trying to recruit. Of course, it can also pose legal risks. Employees suffering from occupational stress may resign. They might try and claim constructive and unfair dismissal, and they might argue that their employer created the problem and did nothing to help when asked. In turn, stress-related illness, which can last for an extended period, may result in disability discrimination claims. You might have seen in particular in the press recently, there's been reports now of a case to do with long COVID. For example, this could be where an employer fails to make reasonable adjustments because they don't necessarily know or believe that this could be a disability-related illness. In cases involving psychological injury, it can also result in personal injury claims. All of those are potentially very costly and will involve significant management time to defend. Next slide for me, please, Jess. Thank you. So what can you do to tackle this risk? How can you reduce this risk? The first thing is to monitor the different working practices that are in place across teams and the business generally. This is good practice with any new policy, but particularly important with hybrid working to make sure it's achieving the positives and minimising the potential negatives. Don't be afraid to ask for staff for feedback. We're seeing quite a lot of clients that are asking questions about this. Staff are more likely to respond honestly if it is anonymous, and if it can be a useful way to identify sticking points quickly, then we'd recommend doing that. You can ask specific questions about whether they feel adequately supported while working from home, whether they can switch off at the end of the day, are they being contacted regularly, etc., etc. You can then review your hybrid working policy, taking the feedback into account. This is something that we're getting quite a few queries on as well. Some clients don't have a hybrid working policy, but want one or need one. Others are just looking to review their hybrid working policy as times are changing. You should consider any extra steps that might be needed to ensure appropriate supervision levels and integration of homework are applicable, so that they know what is expected of them and where to turn if there are any problems. Working patterns should also be monitored to sort of check for any excessive working hours. This is with a view to obviously minimising employee burnout if possible. Obviously, there are naturally peaks and troughs in working patterns. That could be to meet particular demand for a project, but continuous periods of overwork will inevitably cause problems for employees. The thing to do is to think about options like time off in lieu if people have been working excessively for a period of time, or giving them other alternative options, such as maybe a longer break during the day. Managers need to understand the possibility of burnout and be encouraged to keep a lookout for signs. Now, this can be something that's really difficult to do. You might be familiar with managing stress generally, but we'd suggest looking for things like erratic behaviour, dips in performance, silly mistakes, frequent short-term absences. They can all be red flags of a deeper stress-related problem. It's no good telling staff that they can take breaks and switch off online if managers and colleagues don't practice what they preach. They need to think twice before contacting employees late in the evening. Is it really urgent? Is it really necessary? That includes over the weekend if their working hours don't include weekend hours usually, and just make sure that demands are realistic. It goes without saying that if employees do need time off for ill health and stress, then you should be following internal sickness absence procedures with a view to managing them back to work when possible. It's usually a good idea to consider at an early stage if there are any adjustments to work that might help, such as shorter hours, reduced days temporarily, essentially like a staggered return. This will stand you in good stead if it becomes clear further down the line that they are likely to be disabled for the purposes of the Equality Act 2010, and you have an obligation then to look at reasonable adjustments for them. As a general best practice point, implementing an employee wellbeing programme can offer various benefits. It shows employees that you genuinely care for their mental health and physical health and can help support performance and productivity. It encourages a healthy work-life balance, which in turn will reduce the likelihood of employee burnout and the problems that creates for the business. You might consider interactive workshops, working with experienced coaches, running mindfulness sessions. They're all just examples of what you could possibly do. So I'm now going to talk about employer protection and how you can protect the business. Next slide, please, Jess. Thank you. So this is not a new issue. I'm sure we're all fairly familiar with it. It's been an issue throughout the pandemic and the repeated lockdowns. But long-term hybrid working means it's more important than ever to have a cohesive and effective approach. What we're seeing in practice is that there is a danger that there's a two-tier workforce starting to emerge as sort of them and us, office-based employees against regular home workers. Those in the office may benefit from regular colleague collaboration, a face-to-face access to line managers, and possibly end up being allocated better work. In turn, those who are more often at home may start to feel isolated, unsupported, and conscious that they are being sidelined in favour of their office-based colleagues. This can quickly dilute an otherwise positive and inclusive workplace culture and may lead to resentment and dissatisfaction within teams. Employees can feel less loyalty towards their employer and be more open to exploring the market for opportunities to jump ship. Sometimes this will be to a competitor offering a better package, but in other cases, it may be to start up in competition with their current employer. The time out of the spotlight working from home provides an opportunity for employees to refine any plans to move on. They may contact their colleagues off grid to see if there's an appetite to follow them in a team move. That could be over WhatsApp, Teams, any sort of messaging service that they use. And in many cases, there could be an attempt to take their employer's confidential business information to give them a bit of a head start in their new role or business. That information could include key client details, for example. The law relating to confidentiality is fairly complex, with different common law, contractual, and statutory obligations which apply depending on the seniority of the employee and the type of information involved. Most employers have express obligations relating to confidential business information in employment contracts. They're often expressed to continue beyond the termination of employment. But we have come across numerous instances of employees working from home who have simply chosen to ignore their contracts or plead ignorance about the extent of what they have signed up to. That could well be because of the sense of disconnect from their employer, and it's a significant exposure to look out for. Have the next slide, please, Jess. Thank you. So finally, here we thought it'd be helpful to highlight the key steps to protect businesses, which include reviewing existing contractual protection. For example, your confidentiality clauses, your garden leave clauses, post-termination restrictions. If there's anything we can help in that respect, please do let us know. We're also seeing employers who are considering separate confidentiality agreements. That's not a new thing, but it can help to reinforce restrictions. We'd recommend ensuring that relevant policies are clear and accessible. For example, your hybrid working policy and your working from abroad policy, If you do not have these already, they're certainly a useful tool to have, and we'd recommend, if you can, making them accessible. For example, if you've got a staff intranet, put them on the staff intranet. Technology can be used to monitor untoward activity, for example, prohibited access to sites, excessive downloads, printing, etc. We've also recently heard from some clients that some employees now refuse to do effective handovers. This seems to be a bit of a trend and a new thing that hasn't necessarily been there before. Reason being is that they're saying that their sort of digital footprint and everything they do is online or on a system in emails, etc., and that they're not needed to do the handover anymore. So we'd recommend sort of starting to think about that early, and try and get them to assist with effective handovers before they leave. You could also use the employee exit process, ensure they're reminded of their obligations towards the business post-termination, such as the restrictions and other contractual obligations. Finally, we recommend acting on red flags very quickly. We're thinking about this in the context of injunctions. If you think one's going to be necessary, don't wait, don't delay to do that. Make sure you do it straight away, because that could actually lead to an unsuccessful injunction application if there is a delay, even if it doesn't seem that significant to you. So thank you everybody for this morning. I'm now going to hand over to Sasha. Sasha's the partner in the immigration team, and she's going to talk about what sponsor license holders need to know.
Thank you, Kat, and welcome everyone. What I'm going to cover today is maybe familiar to many of you. Basically, I'm going to talk about the sponsorship management system principally. Many of you will be sponsorship license holders, and it's just worth reminding you about your obligations as employers and the key considerations the Home Office take into account for sponsorship license holders. There also have been a number of new rules. I'm going to run through those very briefly because they are detailed and we haven't got time to go into them in much detail, but it's worth going over those just to flag what action you could take and how you can prepare and address the changes. And that's principally by ensuring that you're aware of your obligations as sponsorship license holders and you make sure that you abide by those. And finally, I'm just going to have briefly give some practical examples of what we think may crop up in the context of clients who have come to us with particular issues and problems. Can I have the next slide, please, Jess? Thanks. So worth just stating the overarching principles of being a sponsorship license holder. I mean, the Home Office like to say this again and again. They consider being a sponsorship license holder to be a privilege, not a right. And by that, they mean sponsorship license holders really must be aware of their sponsor duties and what they are required to do. And those of you who are sponsorship license holders will be aware of these already. They're set out in quite lengthy guidance documents that are issued by the Home Office. I don't recommend necessarily reading them page by page, but it's worth knowing what they say generally and in principle. And the duties cover things like reporting certain events, record keeping, just to make sure that you are aware of what the immigration rules require you to do, and that you do show that you are in compliance with those duties and with the wider UK law. For example, ensure that you meet your employment law obligations, including, for example, minimum wage obligations, you've obtained planning permission. All of those things will be issues that the Home Office can check up on, given that you're a sponsorship license holder, and they do have a very wide remit to check. Be aware of key personnel obligations. So those are the obligations beholden on the authorising officer, the key person on the license, the main contact, the key contact on the license, and the level 1 user. And those are the only people that are able to access the sponsorship license via the online portal, and they need to be aware of their duties and obligations around particularly reporting. They need to know what needs to be reported, for example, changes to the organisation, if you've been subject to a merger or takeover, if you know that there are transfer of undertaking protection and employment regulations that apply to you. You need to know what reports you need to be make regarding that, and within what time limit. Just be aware as well of compliance visits. Obviously, these can be, the Home Office can just knock on your door as a sponsorship license holder at any time, announced or unannounced, and come and check and make sure that you are complying with your obligations as sponsored license holders. And I'll just run through a few top tips later and just HR considerations later on in this talk. Can I have the next slide, please? Just a very brief overview of your ongoing reporting and compliance duties. As said, you're required to report certain events to the Home Office, often within very specific timeframes of that event taking place. Usually that timeframe is 10 or 20 working days. And remember that those obligations remain in place if you're a sponsorship license holder, even if you have no or very few sponsored employees. And the kinds of things you'll need to inform the Home Office are things like, with regard to sponsored workers, if there's a change in that sponsored worker's employment, such as job title, change in their job title, in their duties, in if they've been promoted, if their salary has changed. You need to report all of those things on the sponsorship management system, and often, as I say, within a certain time frame. If they've been absent from work for an unauthorized for a certain period of time, if they've not been authorized to take that absence, you need to make a report. If they fail to report to work, and if, for example, their employment's been terminated, you need to ensure that you inform the Home Office. And that's not, as I say at the bottom there, it's not an exhaustive list, but it's an example of the type of things that need to be reported, and the Home Office need to be informed of. Next slide, please, Jess. So yeah, just to carry on with that, I mean, if anything changes within the business, you must make sure that you tell the Home Office that. So those changes could include, for example, a change in the company name, a change in the address, any branch location changes, any of the key personnel, so the authorizing officer, the key contact, or the level 1 user. If any of those people change, the identity of them changes, you must ensure. It's easy to forget, actually. We often come across situations whereby the authorizing officer, for example, has left and the license hasn't been used for a while, and suddenly you need the employer needs to take on an overseas employee, and they find they're not able to do so before appointing another authorizing officer or changing details on the license, and that can take time. So it's really worth reviewing the status of the license very regularly, and we say at least once a month, and always seek advice. If you're confused about whether you need to report a change, just seek advice on that, because it's more likely that you will need to, and it might well be subject to a time limit within which you need to do that. And I always like to remind people of this, which is that it's only certain named personnel who have access to the sponsorship management system, so the online portal. Only level 1 or level 2 users named on the license have access to it. You can't just say to somebody, we need to get a work permit or a certificate of sponsorship for someone. Can you just go onto the sponsorship management system and get that? They need to be named on the license. If you are not named and you access the license, you are in principle in breach and could be subject to sanction. And pleading ignorance of this, it's worth saying, is never an excuse for the Home Office. They expect you to be up to speed with this and to understand what your obligations are. Next slide, please, Jess. So just to reiterate, having a sponsorship license is, as the Home Office keeps saying, a privilege, not a right, and non-compliance can lead them to just revoke or suspend your license. And that can be disastrous for anyone who employs overseas workers or anybody subject to immigration control, because it could mean that those people have their permission to stay in the UK curtailed or cut off, and that means that they'd need to leave, and that could obviously have a very negative impact on the rest of the workforce, and it might mean that the business is unable to function. And worth saying as well that if you do have your license revoked or suspended, or revoked specifically, you can't apply for another one straight away. You have to wait at least 6 months. So it can cause a lot of problem. You can get your license downgraded as well, from an A-rated to a B-rated license, which is a hassle because you'll need to keep reporting and keep contact to the Home Office. You'll need to apply to a plan that they will impose upon you. So it's worth understanding what your obligations are. Can't say it enough. And obviously all of these things, revocation, suspension, downgrading, that could result in the reputational damage to license holders, generally in the marketplace and with the Home Office. Next slide, please, Jess. So I'll just touch really briefly on the key changes, because I could talk about them for a very long time because they are quite detailed, but many of them, a few of them came in, I should say, within the last few months, one very recently, and they're basically additional new visa routes. And the idea being that the Home Office want to retain the UK as a hub for global business and make it an attractive place for international businesses to set up in the UK. So there have been a few new routes. I'm going to talk about the global business mobility route, the new high potential individual route, and the scale up route. And I'm also going to touch on the changes to the right to work checks, because as you'll be aware, you are obliged to undertake those checks with all your employees, whether they be subject to immigration control or not. And there have been a number of changes to those checks that I'll touch on. Next slide, please, Jess. So just to say, first of all, talk about the global business mobility route. And this is basically a rebranding of some existing categories. But the really important thing to remember about this is that you will need to have a specific type of license if you wish to apply for any of these sub-routes that I've listed there. And the most significant one here is the new senior or specialist worker route that basically is a replacement of the intra-company transfer route. It's the same in the sense that you can apply to transfer overseas workers to the UK. Someone from an overseas branch can transfer over to the UK to work, but you need to have a specific license allowing you to do, or specific permission within your license allowing you to do that. The other one that's worth mentioning is the UK expansion worker subcategory of this global business mobility route. And that used to be a sole representative route. It's now slightly more complex in the sense that you have to get a license to transfer or to appoint somebody to come over to the UK to set up a branch here in a way that you used to not have to get a license to do. You now need a license to do that. So this is a sponsored route. And the important thing to remember about this as well is the global business mobility route is only going to allow people to come over for a limited number of years, probably 2 to 3. And thereafter, if they want to stay, they will need to switch into the standard sponsor license route and apply for and obtain skilled worker or used to be known as Tier 2 certificate of sponsorship to enable them to stay on. The idea is that this global business mobility route is supposed to give greater flexibility to employers to move group staff, but it is quite complicated, and that they've got quite a few additional new rules. It's worth being aware of those. So next slide, please, Jess. This is really interesting because what the Home Office have done here is introduced a new route which is designed to encourage and attract highly skilled internationally mobile individuals to the UK. So this is an unsponsored route. This enables people who have graduated from what they call top global universities within the last 5 years to come to the UK without a job offer and work here, and they can switch jobs within the remit of this visa, and they can not work for a while, they can look around for jobs, but they can come without being sponsored, and that is really quite a departure. And those of you who've been working with immigration for a while will remember perhaps the highly skilled migrant route. This is basically a rebranding of that. You can come as a high potential individual if, as I say, you've graduated from a top global university. You need to have done that within the last 5 years, and the top global university lists are published regularly. You'll be granted permission to stay for 2 years if you've got a bachelor's or master's degree, for 3 years if you have a PhD, and you can apply to extend this visa and settle in the UK, but you need to do so by switching into the skilled worker route. So you can come over, set yourself up here, get a job, and then you would need to apply to switch into a skilled worker route if you want to settle permanently here. So that's an interesting new route that's worth knowing about. And I'll just, next slide, please, Jess, just touch very briefly on the scale-up visa route. This is just for companies who can demonstrate that they have an annualized growth of at least 20% for the last 3 years, and that's covering turnover or staffing. You need to have a minimum of 10 employees, and they'll issue a visa, startup visa, a scale-up visa to people who are going to be paid at least £33,000 per annum. The permission's granted for 2 years. You can, with this route, stay for a full 5 years and apply for indefinite leave to remain based on having a scale-up visa route. And you're only going to be tied to your initial sponsor for the first 6 months. You can then change, which is interesting departure. There is an English language requirement you have to meet, but you can bring your family members with you if you come under the scale-up visa route. Next slide, please, Jess. So I said that I would touch on the right to work check changes. There are, as you know, obligations on employers to make sure that you've met these right to work checks, you've undertaken these right to work checks, and during COVID obviously you weren't able to do so in the same way because people weren't going into offices, so they have allowed employers to check remotely, and they've extended that ability to the end of September. They also introduced a number of changes in April, and principally the most important thing about those are that those there are certain people whose checks must be made online. You cannot check those people via using a physical document. That applies to people with a biometric residence permit or a biometric residence card or a frontier permit, which applies to people who are coming in from the EU to work. Those people, you must check their right, give their right to work, make their right to work checks online. Worth updating and making sure that you understand fully what your obligations are. Update your internal online onboarding processes to cover these new rules. And they're also going to be introducing what they're calling an identification document validation technology check, which is going to cover British and Irish citizens who have valid passports. And they're going to be publishing a list of identity service providers through whom you can make those checks. And as soon as they do so, we will publish that list so that you can, and details of how you go about making that check. Next slide, please, Jess. So we had a question, I know, from somebody asking about the impact of the Ukraine crisis. And I guess that the most important thing to say here is that the Home Office are prioritising applications for Ukrainian nationals, and that means that everything else is being delayed. And so you need to count on all sorts of, for all applications in longer processing times. And they've also suspended, as many of you will be aware, the priority and super priority visa processing services for any applications being made from outside of the UK. And basically these delays are having a knock-on effect on the availability of appointments at all levels. So they're basically almost invariably taking much longer to process applications than the service standards. So, you know, things like family applications for spouses or to join children in the UK, for example, those applications are taking around 24 weeks to be processed. And we're not expecting this to improve anytime soon. So top tip here, keep this in mind, plan any moves in plenty of time, try and be flexible with timescales and manage employees' expectations in view of the delays. We're not expecting it to change. So, as I said earlier, other top tips, now's a good time to conduct a review of your license and check whether all of the details are up to date. And I say this because the Home Office are in the process now of emailing level 1 users who haven't logged into the sponsorship management system. They sometimes are emailing authorising officers as well, who haven't logged in regularly, and they're granting them 10 days to log in and check that the details are correct. And if you do receive an email like that, do respond to it, because they will follow up if you don't do so. Next slide, please, Jess. So I thought I'd just run through very briefly a couple of examples just of the kinds of issues that we've been instructed on. So for example, US law firm decides to open a UK-based office. They're going to send one partner over initially. What do they need to do? So this is a good example of when you would use the new global business mobility route, and you'd go for the expansion worker license. This is a specific license you need to apply for. It used to be that you might have, as I said, applied for a sole representative visa for someone like this. You're not going to do that now. You're going to have to apply for a license and then get a certificate of sponsorship for that person. And remember that a person's not going to be able to settle in the UK, get indefinite leave to remain with that particular type of visa. They're going to have to change that visa. So think about the timing on this, and also think about the delays, because it's going to take at least 3 months for the license to be considered and issued. We're finding 12 weeks at a minimum they're taking to issue licenses at the moment. Another example, overseas a business wishes to set up in the UK, but it's a brand new business here, doesn't have any office premises, no employees. What do you need to consider if you're doing that? Well, again, you need to apply for a sponsorship license. That's going to cover skilled workers and specialist workers, so formerly intra-company transferees. You need to think about who's going to be your authorizing officer, make sure they know what their obligations are, and the fact that level 1 users are going to be contacted and to make sure that they understand what their obligations are, and only they can access the license. What are the mandatory documents that you need to provide, given that you haven't got any set up here, where they're going to be things like lease of premises if you have it. You're going to need to register with HMRC. So consider the timing on that, because it can take a while to get those documents, and you're not going to be able to apply until you have them. Finally, just is something that we've been instructed on recently, or regularly actually, EU nationals who are working in the UK, who want to go back to their country of nationality, for example, work from there. What are the implications for their visa? So first thing to think about is, have they got settled or pre-settled status, which is obviously what they were able to do apply for prior to last year, and enables them to stay in the UK. But they will lose that pre-settled or settled status if they're absent from the UK for a lengthy period. And that would mean they need to re-qualify to return. So make sure they're not outside the UK for more than 2 years or 5 years, so that they can retain residence. And for sponsorship license holders, you need to make sure that your compliance obligations are up to date, and that you know what they are, because they will continue to apply even for people who are working abroad or traveling into the UK regularly. Final thing to think about for those who are working abroad is the implications for their indefinite leave to remain. They will be expected to be in the UK continuously. If they're outside of the UK for more than 6 months in any one 12-month period, they will lose the right to apply for indefinite leave. So if they're thinking of trying to work from abroad for the UK business, that's something to bear in mind if they want to stay here long term. So that finalises what I've got to say. Happy to answer any questions, and many thanks.
Thank you very much to Kerry, Kat and Sasha. We have had a few questions in. The first one, I think, maybe one for you, Kerry, is what's the difference between having targets and positive discrimination?
Yeah, thanks, Jo. Targets are essentially sort of aspirational positive action. So it's not the same thing as setting quotas. And I think the key difference is how you work towards achieving the targets. So you can use the positive action that's permitted by the Equality Act. So let's say that you identify that there's a disproportionately low number of employees from an ethnic minority within your workforce, and that's versus the rest of the industry or on a national level. So you can take steps to try and remove any sort of identified disadvantages, say in the recruitment process. So you can target advertising, and you could hold open days to try and encourage more applications. And if you do encourage wider applications, you still are under an obligation to appoint the objectively best candidate for the role. So you can't then just operate a simple blanket policy of recruiting the individual from the ethnic minority versus someone else. So I think that's the key difference. You're trying to encourage participation rather than operating a blanket positive discrimination policy.
Brilliant. Thank you, Kerry. So a very interesting question. we've had that CIPD are currently reporting a PwC study where 2 in 5 companies are reporting wider gender pay gaps in the last year, and that it will take 5 more generations of women for pay gaps to close. The question is the gender pay gap reporting at risk now? I think that's quite interesting given what we have seen in relation to ethnicity pay reporting, where the proposal is that isn't going to be compulsory. And I think perhaps the rise in pay gap is really because we're just starting to see the impact of COVID, which kind of anecdotally appears to have had a greater impact on women within the workforce. I think that D&I records of a business is a significant pull factor for staff, and becoming more so. So even if it becomes not compulsory to report, and I should say we haven't seen any suggestion that might be the case, but I think it's a good thing to bear in mind. But even if it did become non-compulsory, then many businesses might feel that actually they are compelled to address it and perhaps publish it as a sort of recruitment and retention tool. And I think there are reputational issues associated obviously with a wide gap and not being seen to do anything about it. And for those of you in sort of regulated business, particularly financial services, maybe law firms, for example, I think there could be and is likely to be continued regulatory pressure with ESG and D&I becoming so important in terms of issues for regulators now. And then finally, we had a question on whether we should carry out risk assessments with hybrid working, and how on a practical level is that possible. Now, Kat, I know, addressed a lot of the practicalities around monitoring mental health. I mean, one thing I thought of, and we've done certainly here at Fox Williams, is that you can do some degree of checking of the physical environment with video calls, so you can ask people to sort of show you where they're working, etc. And I think that's been a way, and questionnaires with staff to try to monitor it if people can't, or it's not practical to go and visit people in their homes. So those are the questions. We did have some questions that came in advance, and encourage people to do that, but I think we've hopefully addressed most of those in the context of what we've been saying. Just one final point from me, please do, as we said, let us know if you would like to attend an in-person session next time, or a sort of hybrid session. And also just to remind people that we're going to be running another interactive training session with Selwyn Blythe, accompanied by the Forum Theatre actors in September. That's on the 20th, and that's around managing mental health in the workplace, a really live issue for workforces following the pandemic in particular. And those of you who have attended before will, I'm sure, endorse how valuable these sessions really are. So it's an opportunity to discuss and consider some of the practical examples and learn from Selwyn and each other. So we'll be sending out a mailing shortly, and Jess has put into the chat function a link so that people can sign up if they want to do so now. But please do let us know if you're interested in that. It will be a very useful session if past sessions are anything to go by. Slightly run over time. Thank you to those who have stayed, but I hope you found that a very useful session. Thank you for joining us this morning. Thank you to all our speakers, and thank you again to Jess for all her efforts in making these webinars so successful. Thanks very much. Goodbye.